Welcome to another episode of Image Rights by N. Mashineni. This is an early August episode where I will be interviewing one of my favorite authors, Professor Jennifer Rothman. Professor Jennifer Rothman is a professor at the University of Pennsylvania School of Law. She is nationally recognized for her scholarship on intellectual property and constitutional law. She is an elected member of the American Law Institute and serves as an advisor on the restatement of law of torts, defamation, and privacy. Rothman is the author of The Right of Publicity, Privacy Reimagined for a Public World, published by the Harvard University Press. The book is described as the definitive biography of this right. Her most recent article, The First Amendment and the Rights of Publicity, was published in the Yale Law Journal. Her website, Rothman's Roadmap to the Right of Publicity, found at www.rightofpublicityroadmap.com, is the go-to place for the right of publicity questions and news. Before embarking on her legal career, Rothman received an MFA from USC School of Cinematic Arts and worked in the film industry. Good day, Professor Rothman. How are you?
Thank you. Thank you for having me. I'm good.
It's so good to have you here. I'm honored. I'm actually one of those people who visit your site regularly to find out what's new, what's the latest stuff. And I see you have a copy of this book, my favorite book, that you recently published in 2018. And so today I just wanted us to unpack issues around sports players and the right of publicity, because we are in sports season globally. So I thought it would be the perfect time to discuss these issues. Thank you for coming. And so let's start by finding out, what is a right of publicity expert?
Right. Well, maybe we should start by thinking about what the right of publicity is, because it's not a term that's used internationally. It is very much a term of the United States. Now, that doesn't mean that other places don't have something similar. So you refer to it as image rights, someplace personality rights, sometimes it's right of privacy, or, and in the US, the right of publicity and the right of privacy really grew up together, and in many places are sort of one and the same. And it's a right over a person's identity, usually their name or likeness, but can be any indicia of identity. And in the US, the states have different laws that vary somewhat widely, but in broad strokes, the right of publicity protects against unauthorized uses of your identity. And so that's one of the main areas of my scholarship and what that book is about. And sometimes it's thought of as primarily a commercial right or an economic right to get money for uses of your identity, which is very relevant to athletes trying to monetize their identities. But it actually sweeps much more broadly. And so it encompasses also personality-based interests like autonomy and dignity, as well as more market-based interests. And that makes it more similar to other countries that recognize broader personality rights.
All right. So you mentioned that it would be relevant for sports players who maybe even want to make money using their images. Can we get deeper into why the right of publicity is so significant for sports players?
Absolutely. So athletes have long been recognized as very strong endorsers of products, right? Going back to the earliest endorsements in the early 19th century, and probably long before that, athletes were some of the first celebrities. And so if you're looking for someone to try to help you sell your product or advertise your business, an athlete is one type of personality, public figure that you're going to look for to help you sell things. And that makes an athlete have a personality that is commercially valuable in the marketplace. So in terms of the right of publicity, any law that prevents people from using your identity without permission is going to give you rights to monetize your identity. It's not the only right. And so there are others. We have false advertising laws, false endorsement laws. We have trademark law if your identity rises to the level of something that qualifies as a mark. So there are lots of other things you can do to help protect from unauthorized uses. But particularly where the use isn't likely to cause confusion in the marketplace or you're not very famous, the right of publicity gives you additional protections.
If we look at it from a sports law angle, does sports law provide the right to publicity explicitly, or is the right of publicity separate from sports laws?
So I don't think of sports law. There are some laws that are specific to various athletic institutions, right? The Olympics has bylaws, the NCAA here, which regulates college athletics, has various internal laws, but I don't think of it as sport law as something that has its own jurisprudence per se. It's a collection of different laws, whether it's contract law, rights of publicity, trademark law, antitrust law. We could throw them all in there in a constellation, sort of like with entertainment law. It's not really a separate body of law. It's a collection of different laws that intersect in a particular context. So with sports law, there's a host of laws that affect the sporting world and athletics. And the right of publicity just intersects in that because it affects the control over the identity of the athletes.
I heard you earlier mentioning that sports stars would normally then enter into endorsement contracts. And I've seen in the news lately, I won't drop any brand names or any sports names, but I've seen in the news lately, we see people being dropped from certain branding endorsement agreements. Would you say that these agreements are really strict or tough to negotiate and navigate?
Well, there's a few issues that come up with these endorsement contracts and a lot of the athlete deals. So some of them, and I'll just flag, and hopefully we can talk more about this during our conversation. One of my big concerns that, as you've read some of my work, you'll know is that I'm concerned about the possible alienation of publicity rights or personality rights away from the underlying person upon whom they're based, what I call the identity holder. And I think this is particularly concerning with athletes who may not have as much leverage or may not have legal representation when they negotiate some of these deals, particularly younger, as in the States, we're allowing now commercialization of younger athletes in college, even before college. And they may not be as sophisticated or have representation. And to the extent that you can assign forever to someone else the rights over your own name and likeness and identity, that's deeply troubling. And so I've advocated here in the States that we shouldn't allow this particular right to be alienated or taken or transferred away from the person upon whom it's based. So, for example, here, and the contracts have changed a little bit, but it used to be that to get, as a college athlete, to get your scholarship money, to be able to play college athletics, you had to sign a very lengthy contract. It was signed like 60 pages in length. There was no legal representation. And one of those pages happened to assign the rights over the players' names and likenesses to the NCAA forever. And theoretically, that should mean that you can't actually use your name or identity in any other context, whether it's professional athletics or endorsement deals. So one of the things that's concerning about all of these endorsement deals are, what are the provisions of it? Does it sign away this person's name and likeness rights forever to this other company? Maybe not for so much money, and maybe they shouldn't be able to do it anyway. What else does it prevent you from doing? And they're also, and I think you flagged this a little bit, they're also sometimes what are called morals clauses, which is if you do something that they don't like that reflects badly on their brand, you can be dropped. And so it used to be there were various scandals, whether it was Tiger Woods, the well-known golfer, crashed his car, and he was revealed that he was having affairs a number of years ago. Yeah. And then all of his sponsorship deals fell apart, and his value, and there were some economists who studied his value during the aftermath of that, and his value of his identity fell millions of dollars. Since then, he's come back. And some of these things are not, I think, as upsetting to the public. And so brands are sticking with people. And then I was really interested in this Olympics, for people who are watching, the circumstance with Simone Biles, the US gymnast. She had incredible endorsement deals. She was in a lot of advertising leading up to the Olympics, during the Olympics. And then when she withdrew from the team competition, the all-around competition, I was curious if they were going to keep playing her advertising or if they were going to pull it. And they didn't, right? They left them on, which I found, I was very pleased that they left them on, because it was supportive of her and what was going on with her. And, but that's the sort of thing that I think a number of years ago, they probably would have pulled, 10 years ago, I think they would have pulled those ads. And then I don't know what her contracts would have said about that. But she even talked about, in some of her interviews, the pressure of being the face of the games, right? Of being the lead sort of identity surrounding the games, and that she was representing everyone. And so I think you do become a very public figure when you are in these ad campaigns. And I think that's also something that puts pressure on people. They'll also help support them. It is an additional job doing these endorsements. Both in terms of performing in the advertising, but being a spokesperson. And it also helps support the athletes and their athletics. So I think it is a important way to fund athletes and their endeavors.
I think with Simone, the interesting thing is that her pulling out of the games was based on mental health reasons. And perhaps because mental health has really been in the spotlight in recent years, maybe that is one of the reasons why it wouldn't have been such a good move to drop her based on her decision to pull out, because I could see a lot of support coming from her fans, all over the world for her reasons for pulling out of the game. So it's quite an interesting one that you mentioned there. But I also wanted to hear from you, do these agreements also limit a player's ability to enter into multiple contracts with different brands? So are there sort of like these rules that if you are endorsing Nike, for instance, you cannot endorse Adidas at the same time or something like that?
Yes. Well, Nike, the lawyers for Nike would probably not keep their job if they didn't have it be exclusive, at least in the, athletic wear, athletic shoe area. And so a lot of these contracts are exclusive either to that particular product category, or sometimes they're exclusive more broadly. So I think I just heard yesterday that LeBron James, basketball star, signed a very large contract that is exclusive and not just it's supposed to be his only endorsement deal for the next 9 years. And so there are ones that are exclusive. What's most concerning to me is when they're exclusive in multiple categories and a very great duration. 9 is starting to be a little excessive. Here in the state of California, employment contracts are limited to 7 years. And this is, in some sense, a form of such a personal contract that we don't want to last for much in excess of maybe 5 to 7 years. Because it has a great limit, and I haven't read the contract, so I don't know what its boundaries are. But some of them can limit the ability to appear in public, to speak at various events. And so you want to really scrutinize the limits on individual autonomy. But LeBron James was paid a lot of money. So people may be like, well, he can do that. He was paid a lot of money for 9 years. He can't be in business with other companies.
So do these contracts sometimes venture into agreements that last beyond a person's life, or does it depend on the state laws for the right of publicity or even privacy?
Yes. So some of the agreements do cover post-death rights or post-mortem rights. And you're spot on that states vary on whether they extend rights after a person's death, a right of publicity after death, or a post-mortem right of publicity. And in many states that do provide such a right, you can assign it while you're living. So you can assign it to a corporation or relatives, but it need not be relatives, and you can sell it and monetize it before the person has died. And that raises some very complicated questions about why we're affording this post-mortem right. Is it just about the money? Is it about sort of the dignity of the individual? And a few years ago, also sort of revolving around an athletic event at the Super Bowl a couple years ago, Dodge Trucks ran an ad where they had Martin Luther King Jr.'s voice, one of his famous civil rights speeches, over an advertisement for trucks. And people were outraged. It's so offensive to Martin Luther King's legacy and his daughter and his wife's foundation. We're like, we didn't agree to that. It's very offended. We're offended too. But his right of publicity, and in fact, all of his intellectual property rights were actually given after death to his two sons. So they authorized the Dodge commercial. And so it wasn't unauthorized. It was, in fact, authorized to use both his identity, his voice, the recording, the copyrighted material. So it was authorized. Now, were they protecting the dignity of his memory? Or right, they got paid for it. Yeah. And so that just raises these questions of why are we affording these rights after death and who gets to control them? Because if someone owns someone's rights after death, whether it's Martin Luther King Jr. or Elvis, the public has more limited rights to engage with these individuals. And so we're giving rights to someone, and it's money and control to someone, and taking it away from the public's right to engage with these figures.
I like the fact that you're raising the ability of the public to engage with these figures, because my next question is actually something that has come up a lot when I see on social media. I've seen videos of in barbershops, barbers basically giving someone a haircut, but at the same time creating this artistic picture of a sports player like Lionel Messi. I've always wondered, if you are maybe getting paid to create this haircut that depicts a famous person who is generally known for dealing with their right of publicity, then what are the legal consequences of that? And how does the First Amendment right, the right to freedom of speech, influence all of this?
Yeah, well, that's a big question to throw in. The First Amendment here in the US is the protection of the freedom of speech. And so that's going to limit all of these rights in a variety of ways. In terms of and I'll circle back to that in a minute, but the barbershop example, I'm not familiar with that specific one, but you're absolutely right. Whether it's tattoo artists or barbers can manifest as regular artists can in terms of like painters, right? More traditional media, comic book artists, graphic novelists can use images of famous people in their work. And do they need permission to do that? Does raise really important First Amendment questions. And there may be a big difference between advertising that you'll give someone a haircut just like these famous people or a tattoo of particular celebrities versus the individual person who's receiving that and being like, I want my hair to look like Ariana Grande. I want, to have LeBron James on my arm and carry him everywhere I go, right? That's going to be different because it's about an individual choice rather than publicly sort of using that person's identity to draw in customers. It's going to be deemed differently. And in terms of the First Amendment, and this is something I've written about a fair amount, especially in the context of the right of publicity, there's not clear, bright lines of when something is going to be protected free speech and when something is going to be potentially, someone is potentially going to be liable for having used someone else's identity without permission. And before I came on to speak with you, I was thinking of some cases that involve athletes. And 4 different examples. I thought maybe we could think them through because they come out different ways. So 2 of them were allowed and 2 of them weren't. But if we think it through why, it may be harder to see some of these distinctions. So one involves Tiger Woods, who we already talked about. And when he won the famous golf tournament, the Masters tournament in Augusta, Georgia, this was groundbreaking. And Rick Rush, who's a sports artist, he paints athletes, created a painting of Tiger Woods and then made prints of it, which he sold for money. And the image of Tiger Woods it's also in my book and up in my office. You can see him. He's surrounded by other golfers who've also won the tournament, sort of in the background. But Tiger Woods, his likeness is prominent in the front of the image, and there are two pictures of him. And in marketing for the print, the selling of the print, Rick Rush said, "This is a picture of Tiger Woods," which it is, and described him winning. And Tiger Woods, his corporation, which claims to own his right of publicity and all of his trademarks, sued for violation of his right of publicity, his trademarks, for false advertising, false endorsement, and lost on First Amendment grounds, saying that this was transformative work, that it was a protected work of art. All right, now let's compare that with another example with an athlete. Here, let's think about another work of art here, a graphic novel or a comic book, Spawn. If you happen to be a comic book fan, you might know Spawn. And the NHL or professional hockey player, Tony Twist. And the author, McFarlane, of the Spawn comic series, big hockey fan. And so he would embed the names of hockey players into the comic book as characters. And he named one Tony Twistelli, who was like a mob boss enforcer, which was evocative of Tony Twist, the athlete's sort of personality on the ice, but it looked nothing like him. And it was called Tony Twistelli. Tony Twist sued for using his name and identity without permission in the comic book. And there the court rejected the First Amendment defense. And it used a completely different analysis. We don't care whether it transformed him or whether he looked different. He was used because of the value of his identity. And there was associated marketing around that and the association with the hockey player. And so there is liability for violating his right of publicity, and there was a very large judgment in his favor. That's in the context of some works of art. There were two other examples that I thought were worth thinking through as well. One involves the famous football quarterback Joe Montana of the 49ers during their heyday, and the San Francisco Chronicle printed a front page. He was the MVP, I think, in one of the Super Bowls, a front page picture of Joe Montana. And, 49ers win the Super Bowl, Montana, the MVP. Then they subsequently started selling posters, which featured Montana, and he sued. And usually in these cases involving posters where largely you just have the person, it seems like you're selling the person, we tend to have liability. But here the court said no, because it was a reproduction of a news event and a reproduction of the front page of the newspaper. So there it was protected free speech. The last one I'll just throw out to think about involves Michael Jordan, the great basketball player. When he was inducted into the Basketball Hall of Fame, Sports Illustrated did an entire issue all about this. And they sold a lot of advertising, but they also gave some free one-page spreads to supermarkets in exchange for prominent placement at the checkout counter. And two of these supermarkets, local to Chicago, Michael Jordan's hometown, placed one-page spreads congratulating Michael Jordan on his induction into the Hall of Fame, something we might do, right? We might take out, dare say, congratulations. But the supermarkets did it. One of them also happened to have a coupon for steak, which may be more problematic, but the other one seemed to just have a straightforward congratulations, Michael Jordan, and a picture of sneakers with his jersey number. In both instances, the court rejected a First Amendment defense to a right of publicity claim, saying this was largely about commercially exploiting his identity rather than being able to speak and congratulate him. So it was deemed to be commercial advertising and not protected by the First Amendment. So there are ways we could distinguish these cases, but also they're evocative both of the centrality of athletes to much of this litigation because of the value of their identities, but also the muddle of trying to navigate when is something protected speech where we get to talk about these people, even if we're trying to make money off talking about them, and when does it cross the line into having liability for doing so.
It's interesting because, especially when you talk about the Tiger Woods judgment, I remember reading that case and an article that was written by another author, Jasma, who was actually very critical of how the court just quickly applied the transformative principle without actually even first finding whether there was a violation of the right to publicity before applying that test. So it's quite interesting. What do we actually mean by the transformative principle in line with the First Amendment, right? I think it would be good for our listeners to know, what do we mean by this?
Yes. So maybe we'll take a step back. And I recommend, if people want to dig deeper on the First Amendment issues, that they read the article that I recently co-authored with Robert Post that you mentioned in my introduction, because we go through the different tests. So evaluating whether a use is transformative is only one of many different approaches to trying to figure out whether the First Amendment protects against liability for using someone's identity, or allows the use of someone's identity. And it is not the best approach. In fact, it's quite confusing to try to figure out when something's transformative and when it's not, and why are we looking at whether it's transformative or not. And I think what we're really trying to get at is whether it's meaningful speech protected by the First Amendment, or are we essentially just selling toothpaste, right? Yeah. And if it looks more like selling toothpaste, then we say that the First Amendment's not going to protect you from liability for essentially selling somebody else's toothpaste, here essentially from just selling Tiger Woods as Tiger Woods, without any additional speech-related aspects. So I think that I'm not going to defend the transformativeness test. It is extracted from one aspect of copyright law and copyright's fair use defense, which has 4 factors, one of which the U.S. Supreme Court has read in a consideration of whether it transforms the underlying work. And the California Supreme Court said, hey, maybe that'll work when we figure out whether it's okay to use someone's identity. But it's really taken out of context and has caused, I think, more problems than it has solved. And it's particularly troublesome in the context of works that are historical fiction or documentaries or docudramas, because the goal there is often not to transform, if we have a very simplistic understanding of transformation, is not to change it, but to try to reflect reality. And so that test itself can sometimes disfavor, in problematic ways, realistic portrayals. And that's another area when we talk about the public being able to comment on people. We want people to be able to include real people in their works of art, in their novels, in their documentaries, in their feature films, because that's how we engage with the world around us.
It's true, because I've also seen a lot of people on social media, especially in South Africa recently, people are starting to paint their favorite artists as maybe a way of showing their gratitude for the work that they're doing, or sometimes just, as a mere expression of fandom that, I love this particular artist or celebrity or producer, and they create paintings and drawings of them and put them up to show appreciation. So it's quite interesting when you talk about the free speech principles in the US. So I think that the last thing that I would like us to just touch on before we wrap up with this episode is the question of the challenges that you mentioned earlier with the NCAA. And how is it that the right of publicity is it perhaps effectively protecting such athletes, or is there more to be done in the context of the right of publicity for NCAA athletes?
There definitely is. And there's been, and this may not be something that's being tracked around the world, so just a little bit of background here is that college athletics is big business. It makes billions of dollars for the NCAA, of which the players get nothing. And at the same time, the players have been prevented from doing their own endorsement deals or being paid to appear in advertising. And so not only are they not getting a percentage of the large sums that the NCAA is bringing in for themselves and for the universities, but they're not able to get any additional funding themselves. and then often graduate. Some of them go on to professional athletics, but some of the athletes don't and may have lifelong medical problems after the sort of professionalized amateur college athletics. So this has been deemed to be very inequitable, and things sort of came to a head with the NCAA licensing Electronic Arts and others to use the players' identities in a video game. And some of the student athletes sued and said, hey, we didn't give you permission to do this. This circles back to the contract I mentioned at the beginning of our conversation. And the NCAA said, actually, we get to do that because you signed this contract that says we essentially own your name and likeness. So some good things have happened since then. The NCAA has a less onerous contract now for players to sign and has opened the door, and in the aftermath of several states passing laws requiring them to do so, have now allowed the players to sign endorsement deals and to commercialize their identities both before and during college. Now, there are some important limits. They don't have permission to use the NCAA or their teams' uniforms or logos, which might limit some of the endorsement opportunities. But it also creates a potential challenge that worries me. And so this is where I think some law reform in the space of right of publicity is really important. Because as young people's identities and athletes in particular become more commercially valuable, what you're going to have is agents and managers coming out and being like, you're so valuable. You're such a great basketball player. Let me sign this deal with you. And you're going to have young people who aren't represented by lawyers, who don't know how this works, signing over their rights to someone who they think is going to help them. And then instead of the NCAA profiting off their images without paying them, we're going to have these third parties doing so. And so I think it's really important that we clarify that these rights are not transferable. Also, in the US, people who are under 18, their rights of publicity are understood to be owned by their parents. So potentially a parent could sign away forever, unless we change the law or understand the law differently, could sign away forever these child athletes' rights to their own names and likenesses, right? Forever, and they can't get them back. And that is deeply, deeply troubling. And it doesn't have to be that way. So that's the area where I think we really need significant law reform.
Thank you so much for that. It's quite interesting when I'm thinking about even children's rights in South Africa, where basically the upper guardian is the court in our context. So I'm already thinking about how this could play out in our jurisdiction. But we are out of time, and I don't want to keep you longer than what you can stay for. So thank you so much for joining me in this conversation. And I really, really love the work that you do. I'm one of those people who's really always just reading your book, referring back to your book, especially if I'm trying to find something on the US. So I appreciate your scholarship, and I wish you all the best from here forth. And thank you for joining me today.
Thank you for having me. It was a pleasure speaking with you, and hopefully we'll get to meet in real life sometime.
This podcast series is based on research supported by the National Research Foundation of South Africa, grant number 121887. But the views and opinions expressed in this series do not reflect the views and opinions of the National Research Foundation, its management, or its governance structures. Until next time, control your image rights.